According to Black's Law Dictionary, perjury is defined as deliberately making material, false, or misleading statements while under oath. Perjury is a felony under federal law and is punishable by up to 5 years in prison. Introducing Herbert Stettin, a lawyer who has been an appointed judge in Miami for the last 11 years. During this time, Judge Stettin has also held other lucrative positions, such as a privately paid arbitrator and mediator. As a result, the judge routinely accepts money for private services from some of the same lawyers that appear in his official courtroom. This situation should be alarming to all Florida citizens, but most don't even know it's happening. It appears that the checks and balances are simply not working. This film's intention is to present some of the irrefutable evidence of Stettin's conduct while serving as an appointed judge. Exhibit 1. On January 6, 1999, Herbert Stettin received his first temporary judicial appointment. Since 1999, Judge Stettin's appointments have been renewed year after year, foregoing any electoral process. A decade later, Stettin still enjoys all the power and prestige of being a judge. He is eligible for these repeat appointments because of a loophole allowing retired judges to serve temporarily in various state courts. Stettin gained the status of a retired judge because he was elected once in 1976 and then quit right before the end of his 3-year term. Exhibit 2. Each year, all judges in Florida are required to file a financial report known as a Form 6. This sworn public disclosure is intended to provide transparency about a judge's financial interests. The second page is where we need to focus because it includes information about a judge's income and business activities. For those judges who may be unsure about what information to disclose, the Ethics Commission provides detailed instructions, complete with examples. Finally, at the end of Form 6, a judge signs an oath swearing that the information in the report is true, accurate, and complete, or in other words, the truth, the whole truth, and nothing but the truth. Exhibit 3. In June of 2000, Judge Stettin submitted his first financial disclosure as an appointed judge. In Section D, Primary Sources of Income, Stettin declares $193,000 from the collection of accounts receivable by his law firm, Herbert Stettin, PA. He also includes his $49,000 salary as a Florida judge. Stettin represents that he is closing his law firm, which is to be expected, since he swore that he was not engaged in the practice of law directly or indirectly when he applied for his appointment. Finally, in Section E, Judge Stettin disclosed his 100% ownership interest in his law firm and represented that the firm was largely inactive. He gives his home address in Coral Gables as the firm's address. On June 27, 2000, Judge Stettin completed his 1999 Form 6 by signing the oath that all disclosed information was true, accurate, and complete. Exhibit 4. Shortly after becoming a circuit court judge, Stettin also began accepting new employment as a privately paid arbitrator through the American Arbitration Association. This acceptance notice was signed on August 4, 2000. The notice clearly states that payments should be made to Herbert Stettin, PA, at the rate of $275 per hour. So at the same time Judge Stettin is representing to the state of Florida that Herbert Stettin, PA is winding down, the firm starts accepting new private arbitration clients. On bills to the American Arbitration Association, Herbert Stettin, PA was using a billing address at 1 Biscayne Tower, Miami, Florida. However, on Judge Stettin's 2000 Form 6, he clearly declares that Herbert Stettin, PA is inactive and located at his home in Coral Gables. Notice he also fails to identify the source of $27,000 in income received coincidentally from the same location Herbert Stettin, PA is using as a billing address. Perhaps it might be time for a Filling Out Form 6 for Dummies refresher course. The Ethics Commission requires all judges to disclose the name and address of their sources of income. An example clearly states, number 1, if you were a partner in a law firm and your distributive share of partnership gross income exceeded $1,000, then you should list the name of the firm, its address, and the amount of your net distributive share. Under secondary sources of income, the instructions require a judge to identify the major clients of any business in which the judge has an interest. Over the course of the last decade, Judge Stettin has established a consistent pattern of failing to make full and accurate disclosure about his sources of income and business activity. As shown here, year after year, Judge Stettin reports to the Florida Ethics Commission that Herbert Stettin, PA, is inactive, has no major clients, and is located at his home in Coral Gables. It was not until 2005 did Stettin even admit that Herbert Stettin, PA, was providing services. Regardless, Judge Stettin has never adequately identified his sources of income, and he has never disclosed any major clients as required. And each year, Stettin swears that his disclosure is true, accurate, and complete. However, during this entire period, Herbert Stettin, PA, has remained active and provided arbitration services while billing from a business address at 1 Biscayne Tower in Miami. Judge Stettin has used the American Arbitration Association and Herbert Stettin, PA, to enable local lawyers to privately pay a sitting judge more than $275 an hour. These examples paint a telling portrait of Judge Stettin's state of mind while completing his disclosures. In each example, accurate information is crossed out and replaced with inaccurate or incomplete information. To be fair, here's an example of what a proper Form 6 should look like. Note the sources of income and major clients are fully disclosed. Through the years, the fees Judge Stettin collected from these undisclosed sources increased exponentially. Beginning with $27,000 in 2000, Judge Stettin's extrajudicial income has risen to an incredible $900,000, as he reported in 2009. And still, after 10 years, Stettin has never acknowledged that this money is flowing through Herbert Stettin, PA, and more importantly, whether the firm has any major clients that should be disclosed. This graph illustrates the dramatic rise in Stettin's extrajudicial income over the last decade. So let's recap, shall we? Perjury is deliberately making material false or misleading statements while under oath. In 1999, Judge Stettin received a temporary appointment that has effectively lasted for 11 years. Every year he has sworn under oath that his financial reports were true, accurate, and complete. Each one of these reports omits material information about the sources of Judge Stettin's income that is expressly required to be disclosed. Furthermore, the critical representation that Herbert Stettin, PA, was inactive is simply not accurate. Why does Judge Stettin repeatedly swear that his Form 6 filings are true, accurate, and complete? Has Judge Stettin been intentionally hiding his business affairs? Stettin has received millions of dollars while serving as a judge, and the citizens of Florida still do not know where this money comes from. Who has been paying Herbert Stettin, PA, all this money? And more importantly, who's keeping an eye on our judges? Angry yet? If so, write your elected officials today and let them know. Explore www.judgeherbertstettin.com to see the evidence for yourself.